Are you ready to be a trustee or personal representative? I'm attorney Reed Bloodworth, the managing partner of Bloodworth Law in Orlando. I handle trust and probate disputes throughout Florida. I represent trustees and personal representatives, and I also handle disputes for beneficiaries. Today, I'll explain what you'll be asked to do in either position as a trustee or personal representative, so you'll know what's expected and can try to avoid common legal problems and lawsuits. The role of a trustee or personal representative can be confusing. The goal is to not let dates and details fall through the cracks. You don't want a beneficiary accusing you of breach of fiduciary duty or accounting action mishaps. First, let's explain what a trust is. A trust is a legal arrangement created to hold property and assets for another party or parties who are called beneficiaries. Beneficiaries are the individuals or entities specifically named in the trust document to receive the trust's property and assets. Your job as a trustee is to be a corporate or individual manager of the trust. The trust is created for beneficiaries named by the trust creator and often has the benefit of lowering or avoiding taxes upon the trust creator's death. According to Florida statutes, a trustee has the duty to administer the trust in good faith, in accordance with its terms, and for the purposes and interests of the beneficiaries, and in accordance with the laws of Florida. Here are the basic rules and roles for a trustee. 1. You have to administer the trust solely in the interest of the beneficiaries. 2. You have to exercise a reasonable care, skill, and caution in administering the trust. 3. You have to only incur expenses that are reasonable in relation to the trust property, the purposes of the trust, and the skills of the trustee. 4. You must take reasonable steps to take control and protect the trust property. 5. You must keep accurate records, which include reporting to the beneficiaries as the trust requires and required by Florida statutes, and B, potentially preparing and filing a tax return. 6. You can't mix your assets with the assets of the trust. 7. Trust assets must be invested in a way that results in reasonable growth and minimal risk. 8. You must keep separate checking accounts and investment accounts. And 9. You can't use the trust assets for your own benefit. If you're an individual trustee, it's highly advisable to hire an attorney, accountant, or financial advisor to help you manage the trust appropriately. If any disputes or potential disputes arise, you should consult with a trust litigation attorney immediately. The other position you may be asked to handle is that of a personal representative in a probate estate. A probate estate arises when someone dies in Florida and either left a will to address how they wanted their positions to be divided among their beneficiaries, or they died without a will and the probate estate is dispersed pursuant to Florida's intestacy statute. A probate estate consists of anything the person owned at the time of their death, including real estate, vehicles, heirlooms, savings accounts, investments, any other assets. As a personal representative, you must serve notice of the administration on the decedent's surviving spouse, beneficiaries, trustee if that's applicable, and the beneficiaries of that trust, again if that's applicable. You must take possession of all the estate's assets, furnish an inventory of the estate's assets to the beneficiaries. You must provide an accounting to the beneficiaries, determine creditors and put them on notice of the probate estate. You must pay the appropriate debts and expenses of the estate. You must prepare the estate tax return and pay any owed estate taxes. And then distribute the assets of the estate pursuant to the terms of the will, or if there is no will, pursuant to Florida statutes. And then you close the estate. As is the case with a trustee, a personal representative is a fiduciary and shall observe the same standard of care applicable to a trustee. So as you've learned here today, there are a lot of legal and financial responsibilities associated with the positions of acting as a trustee or personal representative. Be sure that you're prepared for these roles. One of the ways that you can ensure you are executing your duties properly is to work with a trust probate attorney with whom you're comfortable. Should you fail to perform these duties, beneficiaries can take legal action against you. Sometimes, when several generations step families, siblings, or friends are involved in a trust or probate estate, you may feel a lot of pressure, and it can be made more difficult by jealous or disappointed beneficiaries. Don't figure these things out or answer these legal questions on your own. Seek the representation of an attorney. If you are experiencing difficulties in fulfilling your duties as a trustee or personal representative, or facing potential lawsuits related to your role as a trustee or personal representative, give me a call. Let's talk about how Bloodworth Law can help.